You've likely heard of the tap out. You know, when a fighter's in the octagon and has had enough and wants to submit to his or her opponent, they tap the mat or the other fighter. The referee then steps in and stops the fight. But what if a fighter agrees to a title fight, goes through all the training, shows up for the publicity tour, but come the day of the fight, they don't want to come out of the dressing room to actually fight? And what if that fighter is just dragged out of the dressing room anyway and forced to fight? I hear they do it in pro wrestling. I don't know. Well, that's sort of a simplification of what is happening with Lindsay Hecox, the transgender athlete who wanted to run for the Boise State women's cross country team. So she sued the state of Idaho after it became the first state to ban transgender women from competing with other women back in 2020. Well, 5 years later, and while trying and failing to make the women's team, Lindsay's lawsuit made it all the way to the Supreme Court. But now Lindsay wants no part of it, saying she's done with all the drama that comes with it. However, a federal court has denied her request for dismissal. Joe Paris dug into the ruling and explains why that judge says this case can't just end.
In a unique ruling, a federal judge has prevented transgender athlete Lindsay Hecox from dismissing her 5-year legal challenge of Idaho's ban on transgender women in sports, despite her no longer wanting to continue the case. The lawsuit challenges Idaho's Fairness in Women's Sports Act, signed by Governor Brad Little in March of 2020. Hecox wanted to compete in track and field for the women's team at Boise State, but was prevented from doing so under the newly signed law. So she filed a suit shortly after, and for a time, she did play women's club soccer. After years of litigation between district and appellate courts, the United States Supreme Court agreed in July of this summer to hear the case alongside a similar one out of West Virginia. All proceedings at the time stayed or paused pending a Supreme Court decision. On September 2nd, 2025, Hecox filed a notice attempting to dismiss her lawsuit altogether. She cited, quote, significant personal and family challenges, including negative publicity from this case and her decision to no longer pursue collegiate sports. Also writing, quote, I have stopped playing women's club soccer at BSU. I no longer attend any team practices or competitions and will not do so. I will not participate in any women's sports that are covered by HB 500 while I'm in Idaho. I will not bring another lawsuit against Idaho House Bill 500 after dismissing my case. U.S. District Court Chief Judge David Nye has now struck down the dismissal attempt, candidly admitting it was a difficult decision, saying the court has struggled with the correct outcome in this matter. He ruled based on fairness and public interest principles, saying, while a plaintiff is the master of his or her complaint, the plaintiff is still bound by principles of fairness and economy. The state of Idaho has defended this case vigorously for years. It would be fundamentally unfair to abandon the issue now on the eve of a final resolution. Judge Nye emphasized the broader stakes, saying Hecox and similarly situated individuals, as well as the citizens of Idaho, deserve to have these important legal questions answered. The Ninth Circuit's decision favoring Hecox has already influenced other cases, including challenges to Arizona's women's sports laws. Judge Nye worried in his writing that dismissal would leave, quote, these critical questions in limbo, adding, if Hecox dismisses this case and the Ninth Circuit's decision is vacated, what is to prevent another individual from taking up Hecox's mantle and bringing an identical suit? The parties and the court would be back to square one. Judge Nye acknowledged that this is an uncomfortable outcome, saying, the problem, of course, is now the court is requiring a party to litigate a case that party no longer wishes to pursue. Such a course of action seems problematic.
So the case remains active, though technically stayed through the Ninth Circuit. This is until the Supreme Court rules. So there's a lot of implications with this across the country, not just what's going on here in Idaho. But Idaho Attorney General Raul Labrador said from day one in office, defending this law has been a top priority because Idaho's daughters deserve fair competition based on biological reality. And this could be heard at the United States Supreme Court as soon as January for those oral arguments. It's also entirely possible, Brian, that the Supreme Court could read the petition from Hecox and say, you know what, she doesn't want to go on with this. We have the case from West Virginia. We can dismiss Idaho's portion. The Supreme Court justices are supposed to talk about this privately when they have their conference tomorrow, Friday.
And I guess, aside from the money and the time spent by the state of Idaho on this case, I would imagine that they really kind of want a definitive ruling on this to say, because they assume it will go in their favor, to say that transgender women cannot compete with other women.
Yes, and I mean, the AG even, said this moments ago in the statement, like he campaigned on this. We know there are many Idaho politicians that promised this to the constituents 5 years ago. It's hard to believe that this, law was signed in right as COVID began in 2020. Still at this point, though, waiting for a final resolution so you can understand the perspective from both sides.
Seems like a lifetime ago. All right.
It does.
Thanks, Joe.